Good afternoon. In this video, we are going to speak a little bit about how the ECJ is interpreting VAT directive inside the European Union. The value added tax, commonly known as VAT, in the European Union is a general, broadly based consumption tax assessed on the value added to goods and services. Its regulation is inside the Council Directive 2006/112, and this is the new version of the original 6th Council Directive on VAT. And this one was for 1977. Each member state is responsible for the transposition of these provisions, those contained in this directive, into national legislation, and also in charge of their correct application within its territory. Very briefly, this is the way in how the VAT works at European level, but also inside each member state. We have the VAT charge on sales, commonly known as output tax. Also the VAT paid on purchases, known as input tax. So if we have this output tax minus this input tax, we are going to obtain the quantity that we have to pay on VAT, or maybe if the input tax is higher than the output one, the credit that we can compensate in following periods. If we are doing an operation that is exempt of tax, if we have no output tax, we cannot deduct the input tax in this situation. And this information is useful for the following case that we are going to analyze. In this landmark case of the ECJ Halifax, we are going to talk a little bit more about VAT. This preliminary ruling relates to the interpretation of the former directive on VAT, this 6th directive that we have said before. In this particular case, the reference was made in proceedings brought by Halifax, Leeds Development, and County, 3 different corporations, against the tax authorities of the United Kingdom in relation to the rejection of this tax authority for the application for recovery from VAT submitted by Leeds Development and County, the companies that we have said, under a scheme designed to reduce the tax burden of the Halifax group. Article 2 of the 6th directive provides that the supply of goods and services effected for consideration within the territory of the country by a taxable person is to be subject to VAT. Taxable person means any person who independently carries out an economic activity. Under Article 13 of the 6th directive, the member states are required to exempt the leasing or letting of real estate, also known as immovable property. By its part, Article 13b of the 6th directive states that the member states are to exempt from VAT certain activities in the financial services sector. So in these cases, we are not going to have output tax, so output VAT. So if we do not have output VAT, we cannot deduct the input VAT that we have supported by our suppliers. Article 17 of the 6th directive provides the following statement. Insofar as the goods and services are used for the purposes of his taxable taxations, the taxable person shall be entitled to deduct from the tax which he is liable to pay, so the output VAT, the value added tax paid within the territory of the country in respect of goods or services supplied to him, so the input tax. According to Article 17, each taxable person has the right to deduct from the output tax the input tax. Halifax, in this particular case, Halifax was a banking company. The greatest proportion of the services provided by Halifax was exempt of VAT. For this reason, Halifax was only able to recover less than 5% of its input VAT. By its part, Leeds Development is a property development company, and County is a property development and investment company inside the same group. Leeds Development and County, and also another member of the Halifax group involved in the transaction at property, each of them were subsidiaries of Halifax. So in this case, the Halifax was the parent of the group of companies, and those three, Leeds Development, County, and Property, were the subsidiaries, completely owned by Halifax. Halifax needed to construct call centers on 4 different locations inside the United Kingdom for business purposes. Halifax, the group of company, designed a complex scheme involving Leeds Development, County, and Property, with which is signed a number of agreements, among them including loans and leases. After that, one of the subsidiaries, Leeds Development, entered into agreement with an independent builder for the construction of the 4 call centers. So first of all, there were lots of operation transactions among them. And finally, one of the subsidiaries contract with an independent party outside this group. The successful achievement of these different transactions will result in Halifax being able to fully recover the input VAT for the construction and development of the 4 call centers by the independent part, this builder. The tax authorities of the United Kingdom refused the deduction claim made by the subsidiaries, considering that the transactions between the subsidiaries and the independent builders did not fall under the scope of VAT. According to the tax authorities of the United Kingdom, only Halifax, the parent of this group, have the right to claim the deduction for those transactions, applying its normal recovery percentage that, as we have said before, it was just 5% approximately on each operation. Halifax and its 3 subsidiaries appealed the decisions, alleging that all the transactions made under the scheme were genuine and also reported profits for the parties involved. So this scheme, according to its opinion, according to Halifax's opinion, this scheme was not created in order to procure a tax benefit regarding VAT. The tax authorities consider that the transaction had the unique purpose of VAT avoidance. And what about the opinion of the ECJ in this situation? According to the Court of Justice, transactions of the kind at issue, in this particular issue, are supplies of goods or services and an economic activity within the meaning of the 6th directive. So in this case, the European Court of Justice understood that there was a supply of goods and services inside an economic activity. Nevertheless, those criteria are not satisfied where tax is evaded. For example, by means of untruthful tax returns. The fact, nevertheless, remains that the question if a given transaction is carried out for the unique purpose of obtaining a tax advantage is irrelevant in the moment of determining if it constitutes a supply of goods or services. So apart from the consideration that maybe in this situation there is a tax avoidance scheme, according to the opinion of the ECJ, also in this situation we have an economic activity and also a supply of goods or services. The application, taking this statement into account, the application of EU law cannot be extended to cover abusive practices by economic operators. So in particular, in the context of VAT, an abusive practice can be found to exist only if the transactions concerned result in the accrual of a tax advantage contrary to the purpose of the VIII directive. So for being able to determine that we have a case of tax avoidance or tax abuse in the field of VAT, it must be taking into account different factors, that the essential aim of the transaction, the operation, is to obtain a tax advantage. So the main purpose of this scheme inside the Halifax group should be the obtainment of a tax advantage. Taking this into account, to allow taxable persons, in this case Halifax, to deduct all input VAT, it is necessary to comply with the objective and rules of the VIII directive. And the main purpose of this regulation inside the European Union is the fiscal neutrality principle. Finally, to summarize the opinion of the ECJ in this particular and very important case in the field of VAT, the ECJ understood that the VIII directive, and obviously also the new directive of 2006, must be interpreted as precluding as prohibiting any right of a taxable person to deduct input VAT if the transaction from which that input VAT derives constitute an abusive practice. So the conclusion, the final statement of the ECJ were that if there is an abusive practice, the transaction involved must be redefined so as to reestablish the situation that have been not complied with. So in this case, the final solution was to only permit to deduct a 5% of the amount of the input VAT that Halifax had. Thank you very much for your attention, and enjoy the video. Thank you.